Okay, Linda, you can go now.
Okay, great. Can everyone hear me?
Yes.
Yes.
All right. Again, thank you for accommodating me by phone today. And I apologize, but could the witness pronounce his last name for me?
Barzak.
Barzak. Okay. Did I say it correctly?
Yes.
Barzak?
Yes,
All right.
thanks.
All right. And Mr. Barzak, I understand that you recently had your own loss, and I want to just extend my condolences.
Yeah, thank you very much. Thank you.
All right, so I want to refer to the defibrillator contract, and I may need your assistance. My understanding, and please correct me if I'm wrong, is that plaintiff counsel marked the Parker Tower Condominium Association Operation Heartbeat Hallandale Beach Public Access Defibrillation Program Agreement that was entered into on May 1st of 2010 as Exhibit 5. Am I correct?
Yes.
Okay. What did plaintiff counsel mark? What exhibit is the August 6, 2010 letter from City of Hallandale Beach?
Exhibit 4.
All right. Okay, so do you have those two things in front of you, sir?
Yes.
And you've had the opportunity, at least in this deposition, to review both?
Yes.
Okay. So, earlier you stated, I believe, that you didn't look for a letter terminating this contract because you wouldn't look for something you weren't even aware of, meaning the contract Exhibit 5, right?
Correct.
Okay. And in fact, you don't know if Parker Tower ever sent a letter out terminating the contract Exhibit 5. That's correct?
Correct.
But we do know, sitting here today, as evidenced on Exhibit 4, that the City of Hallandale Beach actually sent out the letter terminating the defibrillator contract, correct?
Objection to form
Yes.
calls for legal conclusion. Document speaks for itself.
And you're making speaking objections. You can keep it to
I
the
follow the rule established by my opponent.
I see. I'll keep that in mind.
You think
All right.
it's appropriate? I think it's appropriate then.
All right, Mr. Barzak, continue.
So,
If you comply with the rule, I can comply with the rule. But since you can't,
Okay, so the speeches can stop. I'm going to question the witness so you can get on to your next
you
opinion.
can cut me off, but I can't cut you off. That's the rule.
Well, I don't know that I would cut you off. Anyway, Mr. Barzak,
yes.
if you look at Exhibit 5, on page 1 of Exhibit 5, paragraph 2, under term, does the term in fact state that termination of this agreement may be effected by either party, provided that 30 days written notice is given by the terminating party?
Objection to form. Document speaks for itself.
Correct. That's what it says.
Okay. And can we agree that Exhibit 5, at least by the terms of Exhibit 5, it was entered into on May 1 of 2010?
Correct.
Can we agree that on the signature page for the agreement, at the bottom, there doesn't appear to be any other date?
Correct.
Okay. And can we agree that the person who signed the contract Exhibit 5 on behalf of Parker Tower Condominium was Leo Saladino?
Correct.
Okay. Can we agree that this is the only defibrillator contract with the city of Hallandale Beach that you are aware of as far as Parker Tower ever entering into it, if it in fact did?
Objection to the form.
Yes.
Okay. And sitting here today, my understanding of your testimony was that you're not even sure that Mr. Saladino entered into this contract on behalf of Parker Tower with the authority of Parker Tower, because there's only one signature, not two. Is that right, by Parker Tower?
Objection to the form.
Yes.
All right. So, referring back to Exhibit 4, the letter from the city of Hallandale Beach, can we agree that that is dated after the effective term of after the initial date, or after the date that the defibrillator contract was entered into?
Yes.
Objection to the form.
Okay, so the defibrillator contract was entered into on May 1 of 2010, and the letter, Exhibit 4, from the city of Hallandale Beach is dated August 6, 2010, after the contract, right?
Objection
Correct.
to the form.
And can we agree that this letter from the city of Hallandale Beach, or strike that, can we agree that the city of Hallandale Beach was one of the parties to the defibrillator contract, Exhibit 5?
Yes.
All right, and can we agree that this letter, Exhibit 4, from the city of Hallandale Beach, specifically states that the agreement will expire on December 31, 2012?
Yes.
Objection to the form.
Can we agree that the letter from the city of Hallandale Beach, Exhibit 4, in fact refers specifically to the contract that would expire on December 31, 2012, and it names the contract as Operation Heartbeat Hallandale Beach Public Access Defibrillation Program Agreement?
Yes.
Objection to the form.
Okay, and so is it your understanding that the Exhibit 4, the August 6, 2010 letter from the city of Hallandale Beach to Parker Tower, in fact refers to Exhibit 5?
Objection to follow.
Yes.
All right. And then is it your understanding, therefore, sir, that the defibrillator contract by operation of the city of Hallandale Beach, in fact, terminated on December 31, 2012?
Objection to the form. Calls for a legal conclusion. Also argumentative.
Yes.
Assumes facts not in evidence.
I mean, sir,
Calls for speculation.
Sir, as a member of the board, I understand that you weren't aware of these documents at the time you started your position with the board in January of 2015. But as a member of the board, since you started that position in January of 2015, can we agree that this contract was not in effect?
Objection to form. Calls for legal conclusion. Assumes facts not in evidence. Calls for speculation.
Yeah. When I got the copy of this agreement, that's how I read it. So.
Okay. And, I mean, Parker Tower, do you know how old Parker Tower is, the association?
I want to say we're going to have a 40-year inspection this year, so it's 78, I guess.
Did you say 40 years?
40 years is coming up this year.
Okay. So, I mean, in all of those 40 years, I'm sure from your experience on the board, at least from January of 2015, you're, and from being a resident there as well, you're aware that Parker Tower from time to time enters into a variety of agreements with vendors, with suppliers, with construction companies, with the city. Is that right?
Yes.
Okay. And you're aware that, you know, these contracts don't don't go on for infinity. They have a termination point, right?
Objection to form.
Yes.
Okay. I mean, you're aware that contracts that Parker Tower has entered into in the past, let's say the construction contracts that it entered into for refurbishing the property as you've described previously, I mean, at a certain point those contracts came to an end, right?
Objection to form.
Yes. All these contracts had dates, start and end dates.
Okay. And once contracts, such as the contract, let's say, with the prior property manager, let's say Castle Group, once that contract with Castle Group came to an end, you, on behalf of, or Parker Tower, would not go forward and comply with the terms of that contract because it had expired, correct?
Objection to form. Calls for legal conclusion. Argumentative. Assumes facts not in evidence.
Well, I think Castle Group, we actually terminated the contract per contract, per conditions of the contract. But yes, in general, that's what happens.
Okay, so with Castle Group, when Parker Tower terminated that contract, is it your understanding that Parker Tower no longer owed any duty, to fulfill the terms of that contract with Castle Group, and Castle Group likewise no longer owed any duties of maintenance or security or anything of that sort to Parker Tower?
Objection to form. Calls for legal conclusion. Argumentative. Assumes facts not in evidence.
Well, in the case of Castle Group, they actually owed us documents, and they've never provided documents, and we're actually still trying to obtain these documents. But in general, when we terminate contracts, yes, it's the relationship is terminated. So, nobody owes anybody to anybody after that.
Okay, and the contract that we see in Exhibit 5 and the letter Exhibit 4, which terminated that contract as of December 31, 2012.
Yeah.
Can we agree that in December of 2015, when this incident occurred, that there was no agreement between Parker Tower and the city of Hallandale Beach to supply a defibrillator or to provide a defibrillator or to equip Parker Tower with a defibrillator or any of its residents or guests?
Objection to form. Calls for a legal conclusion. Assumes facts not in evidence. Argumentative and speculative.
Well, based on the documents I read, yes. Based on the letter and based on both Exhibits 4 and 5, I guess that's what it seems to me as well.
Okay, so you would not have expected for Parker Tower in December of 2015 to have a defibrillator, even if it was still on its premises because it hadn't been returned to the city. You would not expect that defibrillator to be displayed or accessible or available to anyone at Parker Tower, correct?
Same objection. Objection to form. Calls for speculation. Calls for legal conclusions. Argumentative. Assumes facts not in evidence.
Yes, I mean, as I said, based on the contracts that I've received and based on, what I've read, that seems to be the case.
All right, and I may have missed it in your testimony, but who was I know you mentioned a woman who you didn't recall her last name as property manager. I think you said Barbara in 2010.
No, yeah. The 2010 was Barbara, I believe it was Barbara Alvarez.
Alvarez, okay. Do you know who the property manager was in November or December of 2012 when this contract Exhibit 5 was expiring or terminated?
Objection to form, assumes facts not in evidence, argumentative, speculative.
I have to look at the AMG contract, but I would think it would be somebody from AMG.
Are you saying A and G or AMG?
No, AMG, American Management Group, I think.
Okay.
I think that's the name. I believe, yeah.
So, and plaintiff counsel took you through the terms of the contract to some extent, and back on page 1 of Exhibit 5, under terms, where it says all equipment and supplies must be returned to the city prior to the end of the 30-day termination notice period. So, can we agree that the end of the termination notice period, according to the city's letter, Exhibit 4, was December of 2012?
Objection to form, legal, it requires a legal conclusion, assumes facts not in evidence, argumentative, and speculative.
But yeah, I think that's the termination period.
Okay, so does it appear to you from Exhibit 5 that the equipment was actually supposed to be returned 30 days prior to the termination date, like maybe in November of 2012?
Yes.
Same objection.
Okay, so can we agree that when the responsibility to return this equipment, the date that occurred, the responsibility to return this equipment, either November or December 2012, that Universal was not the property manager at that time?
Objection to form, same objection.
Correct. They were not property manager.
Okay, and can we agree that Universal therefore did not have any responsibility to return this equipment pursuant to the terms of Exhibit 4 and 5?
Same objection.
Yeah, I mean, it seems that way.
Can we agree that given the termination date of this contract, Exhibit 5, in accordance with Exhibit 4, that Universal had no obligations or duties under the contract?
Objection to form, assumes facts not in evidence, assumes a legal conclusion, speculation, and argumentative.
Yeah, I mean, I read the same thing when I read these contracts. That it was before Universal's time.
Okay, so Universal, under the contracts, Exhibit 5, and pursuant to the termination notice, Exhibit 4, had no duty to maintain this equipment or to display it in any way on the premises, correct?
Yes.
Objection to form, assumes facts not in evidence, argumentative, requires a legal conclusion, and is speculative.
All right, sir, thank you very much. That's all I have.
Okay. Mr. Barzak,
Yes.
let's
Oh,
go
we're
back.
not done yet?
No, we're not done yet. Let's go back to Exhibit 4,
Who's kidding?
the letter.
All right.
Okay? The letter says, well, first of all, the letter is not part of the contract, correct?
Objective form calls for legal conclusion, calls for speculation, assumes facts not in evidence.
I got both of them together.
All right,
So
that's not my question. My
Yes.
question is, the contract is dated May 1st, 2010.
Yes.
And the letter is dated August 6th, 2010, correct?
The dates are different. Yes.
Two different documents.
Two different
Two
documents.
different dates.
Yes.
Okay. The letter is not a part of the contract.
Objective form.
Yes.
Okay. The letter doesn't say that the contract is terminated, does it?
Well, it says the agreement will expire.
Yes or
December
no?
12th.
It doesn't say, the contract is terminated. It says the contract will expire.
Objective form, the witness needs to answer the question originally asked.
Yes.
Which was?
I don't even know.
It doesn't say terminated.
It says will expire.
Right.
Yeah.
It doesn't say the city of Hallandale Beach hereby terminates the contract effective December 31st, 2012. Does it? Doesn't say that.
It doesn't say, it says will expire in a future date.
Right.
So-
It says the contract says the agreement will expire on December 31st, 2012.
Right.
Okay. But the agreement, which the letter is not a part of, the actual agreement in paragraph 2, says the term of the agreement will begin on the date of execution and will automatically renew annually from the date of execution unless terminated by either party. Correct? That's what it says.
Okay. Yes.
Objective form,
Right?
Yes.
Okay. And you're not aware of any termination letter from Parker Towers?
objective form, asked and answered. He said it expired.
No, he didn't. And you're testifying for the witness. Move to strike. Refrain. Restrain yourself, counsel.
I'm not
I know
sure.
it's hard, but
There's no
please,
question, just-
try.
You
Try
just
for
said-
all. Try for all of us. Try for all of us. Make life easy.
You do the same.
You started it. I just follow suit. Correct?
I'm not sure what I'm answering.
Objective
Honestly.
form.
Question is paragraph 2, term,
Okay.
says the term of the agreement will begin on the execution and will automatically renew annually from the date of execution unless terminated by either party, correct?
Yes.
Okay, we went through that. And I think we went through also the fact that Parker Towers, you're not aware of any termination letter from Parker Towers terminating the contract, correct?
Objective form.
Join.
I don't know one way or the other.
Right, okay. And the letter dated August 6, 2010 from the city doesn't say the contract is terminated. It says the agreement will expire.
Okay.
Objective
Right?
form.
Well, it says, yeah, the agreement will expire.
Right, okay. Doesn't use the word termination. Nowhere in the letter does it say termination, correct?
Objection to form.
Right?
Yes, it
Okay.
says will expire.
And then even after December 31st, 2012, Parker Towers continued to maintain possession of the AED.
Objection to form.
When you say continues to maintain possession,
You didn't return it.
Objection to form.
it seems like it wasn't returned, but I'm not sure who exactly was at fault with that. It could have been the Parker Towers admission. It could have been the city's admission.
That's
I have
not
no
my
idea.
question. My question is, it was still on
It
the
was still on the-
property as of December 28th, 2015,
It
correct?
seems that way. Yes.
And in fact, you continue to have an AED on the property, even as of this date.
They reinstalled it. Martha and fire department reinstalled it, and again, it was without the board's knowledge or consent. So we have no idea why it got reinstalled.
But it's there.
It's
Now.
there right now.
Okay. Do you know whether a new agreement was entered into?
Objective form, asked and answered.
I would imagine not, because I would have to sign it, or one of us on the board will have to sign it. I'm not aware of anybody signing or discussing it.
Okay, so the old agreement then would still be in place if you didn't sign a new one.
Objection to form.
Objective form calls for speculation, calls for legal conclusion, way outside the scope of this witness's expertise or knowledge.
Right.
You're not aware of signing a new one?
I'm not aware of signing.
You're not aware that Martha signed a new one?
Correct. I just don't know.
But you still have the AED
Yes.
on the property, but this time mounted on the wall
Right.
next to the security desk.
Objection affirmed.
Okay. That's it, no more questions.
Would you like to read or waive this transfer?
We will read.
Okay.
Thank you, goodbye.